Alrighty, and good afternoon, good evening, and good night, and welcome back. How we doing, folks? Let me just double check that the audio is working and I'm not talking to myself. Yep, good, that's fine. And we're going to go across here, and we're going to make sure that we are back on that, so that's fine. Welcome back for more of the Karen Retrial. Hopefully we're going to get through, well, I mean, we're definitely going to get through the end of day 10 and make good headway into day 11. Very much hoping to make sure that I manage through as much of day 11 today, because it's Friday. I don't really have any excuse, and I now don't have to get up and go and see a client first thing in the morning. Yes, that's right. I work on Saturdays, unfortunately, but fingers crossed we can get all through it. But let's get stuck into it, shall we? Hello, Demon's Wrath. How you doing?
To the edge of the driveway, sort of on the wrong.
All right, so we are continuing with Jackson giving cross-examination to Massachusetts State Police Officer Lieutenant Kevin O'Hara. O'Hara the dog.
Same side as 34 Fairview, sir.
Understood. So the area and the grid area that you ultimately decided to search and ultimately were directed to search, that was all behind you?
Yes, it was.
And it was dark out, obviously.
Yes, it was, sir.
Getting dark.
Do you prefer
It was dark. It was winter, so it was dark.
You want me to use the full white rabbit hand?
Your focus was certainly not on the area behind you at that point, correct?
That's all right, mate. I should
As a matter of fact, your focus wasn't really anywhere, was it? Because
No.
you didn't know where you were going to search.
Correct, sir.
Okay. Ultimately, your team members began to arrive one by one, and each one of them would stay in their car, or would they get out and come coordinate with you, like at your cruiser?
No, as they arrived on scene, they would come out because Lieutenant Tully had already arrived on scene. He was technically the third member of the state police on scene.
Okay.
So once he got on scene, I was already out talking to him, and I was marking off the area we were going to search.
Understood. He ultimately, at some point, did direct you to a location behind you, which you were not currently focused on, toward the flagpole, the fire hydrant, you said.
Yeah, I wasn't focused on any area at that time, sir, no.
You marked those the areas out that Lieutenant Tully directed you to with some sort of grid coordinates, or was it just sort of a mental grid?
No, I wanted marking, stepping it off in the area I wanted to search, sir.
Did you use any string or rope or anything like that to physically grid the area off?
No, I just marked a line in the snow, sir, where we wanted to start and where we wanted to end.
And you did that with footprints?
No, with the shovel, I made a mark where we wanted to start and end,
I
sir.
see. So sort of dragging a shovel in the line.
Oh,
in the
just
snow.
where the berm was, sir. I knocked the berm down, made an obvious impression of where the shovel was.
Okay.
At the starting location where ideally I wanted to end.
Perfect. You indicated that the area that you were searching was relatively undisturbed snow. You said that in direct examination, correct?
It was undisturbed, yes, sir.
But
right,
the
Gabby.
Street, everything from the berm in, the street had been
Rachel.
plowed, correct?
To a point, yes, sir.
All right. And so that would be disturbed snow.
Yeah, to a point, yes, sir.
And what was the point?
To where the snow that got plowed in, it all rose up just like the end of your driveway would. There was a good 3 to 4 foot high barrier on each side of the street. Once you were able to knock down that initial barrier of snow, the level of snow dropped down to the normal depths that you would have seen in anyone's front lawn at that time, sir.
And is that what you're calling the undisturbed portion of the snow?
Correct, sir.
Okay. Lieutenant Tully told you that you were going to be looking for a man's shoe, a sneaker of some sort, or a shoe of some sort, correct?
I said sneaker, yes, sir.
And he told you that you'd be searching for plastic, red plastic potentially from a taillight. Is that right?
I said taillight pieces, yes, sir.
Did he indicate that some of them would be red, some might be clear, might be a combination of the two?
He didn't indicate a color either way, sir.
He did direct you to where he believed you should search. It was his direction that sort of gave you your grid coordinates, correct?
He indicated where the vehicle had been parked and where the victim's body had been located and suggested that was the primary area to search.
Did he tell you whether or not he knew from personal knowledge where where John O'Keefe's body had been?
He did not, sir, no.
Did he tell you whether he had personal knowledge where any taillight material might be?
He did not know, sir.
Did he tell you that he had any personal knowledge where an impact site might have been?
He did not know.
Did he tell you that he had personal knowledge that there had been an impact site at the location?
No, he just said he believed the incident involved the vehicle.
Okay. One of your goals when looking at the search location was to obviously remove the snow as methodically as you could, correct?
Yes, sir.
You wanted to not only remove layers of snow, but then ultimately expose the layer beneath it with as little disturbance as possible. Is that right?
Correct, sir.
I think you noted that the plow had not plowed all the way to the curb, so the snowbank was sort of in the street, not in the yard, or at least a few inches from the curb line and not in the yard, correct?
Correct, sir. As I stated, as some of the responding members parked, they were thinking they were parking in a safe spot in the street, and their cruisers wound up being stuck at the end of the night.
And you and your team had some experience doing searches in snowy conditions, being from Massachusetts, I'm guessing.
Missing person searches, we've never been out for an evidence search in this specific type of conditions, but we have done missing person searches.
So this was the first time you and your team had executed a search of this nature in these kinds of conditions for these kinds of items? In
blizzard conditions, yes, for an evidence search, yes.
But you did indicate on direct examination that although it was blizzard conditions and the winds were high, and we learned that windy conditions sort of define a blizzard in some respects, the visibility was relatively good.
Yeah, with our headlamps, we had pretty decent visibility.
I want to ask you a couple of questions about the techniques for conducting a search like this in some sort of snowfall. Obviously, as a specialist in searches, one of the things that you put as the highest priority is documenting exactly where the search is conducted, what techniques are used to conduct the search, and what, if anything, is found and exactly where it's found, correct?
Yes, documentation of your search is important, yes, sir.
You'd also want to document the time that things are found, correct?
Yes, you want those documented.
And you'd want to document the relative locations between and among items that are found. How close are they to each other? How close are they or far are they from a stable landmark, a static landmark, correct?
So we will mark items, sir. Okay. Measuring in between distances, they do get stamped when we mark our items. Measuring them would be at the discretion of the investigators themselves.
And obviously that would be among the best practices to clearly document how a search is conducted, correct?
Correct, sir.
Another way to document the evidence or the search is to do it through either video evidence or photographic techniques, right? Just photographing, forensic photographs of where things are found, contextual photographs moving into close-up photographs, correct?
That would be at the discretion of the detective, sir.
And in this case, that discretion lay with Lieutenant Tully, correct?
Yeah, he was the incident commander, correct, sir.
You indicated a number of hand tools that you brought with you to the search to make sure that you had the tools necessary to get through the snow and get to the items if there were any items out there, to get to the items you were looking for. Is that right?
Correct, sir.
And you did, in fact, remove layer by layer of snow and sort of sift through it as best you could, correct?
Yes, sir.
That also included some shovels where a shovel full of snow might be gathered and then turned over, correct?
Yes, sir.
All right. That was done somewhat methodically, is that right?
Yes, it was, sir.
And you wanted to make sure that you weren't missing anything as you were digging through the top layers of snow and getting down to something closer to the surface, correct?
Correct, sir.
And at that time, what was the level of snow, if you can estimate it? How much snowfall?
I believe the area, not living that far from that location myself, was anywhere from 15 to 18 up to maybe 20 inches in certain towns.
And again, this is after 5:45, 5:48 in the evening of January 29th.
When the first item was discovered was 5:45.
Okay.
Yes, sir.
Obviously, a search of this complexity and with this many individuals and with those conditions required some level of significant coordination by you and your team, correct?
Yes, sir.
You had to account for all the personnel who were there. Is that right?
Correct, sir.
That included, I'm going to go through a quick list: Bearden, Beausoleil, Carrier, Luis, O'Brien, O'Hara, you, and Biscardi. Is that right?
Yes, sir.
So there were 7 individuals, as well, Lieutenant, as 7 vehicles to account for and make sure you're not driving over the wrong areas, walking over the wrong areas, standing over the wrong areas, correct?
Correct, sir.
And not only did you have to account for those 7 officers, each of whom arrived in their own vehicles, you also had to make sure that those vehicles were positioned in the right spot to make sure you don't drive over the area that you need to search and might be impacted by your cars, correct?
Yes, sir. After Lieutenant Tully arrived on scene, the remaining cruisers never came past the initial location of where we believe the incident occurred.
Before he came on scene, the cruisers that were there were down toward the driveway, closer to where you were, and you, of course, were positioned with your back to the location that ultimately was searched, correct?
Yes, sir. That was 2 of the 7 cruisers, yes.
Okay. Once you learned where you wanted to search, you literally had to sort of turn around, physically turn things around to begin searching behind where you had originally positioned yourself. No fault of your own, you just didn't know where to go. You had to sort of turn around and go backward toward the area of the flagpole, away from the area of the driveway, correct?
Yes, sir.
And so as you began to focus on the other side of the house, the other side of the driveway, you had to actually reposition a couple of the cruisers. You didn't have to, but you chose to reposition a couple of the cruisers to turn their lights back around, correct?
Oh, that is correct, sir.
At some point, you've indicated that there were other individuals who you noticed were at the scene. Is that right?
Yes, there were non-cert members on scene, sir.
Okay. And those non-cert members included, or they numbered at least 5 individuals, not including Lieutenant Tully. Is that right?
I believe that includes Lieutenant Tully, sir. I believe it was 5 total.
Okay, so 5 does include Lieutenant Tully. There were 4 others that were non-cert members, correct?
Correct, sir.
And those were members, I think you've earlier testified that those were members of either Massachusetts State Police or Canton Police or both. Is that right?
I believe it was both, yes, sir.
And you did not recognize those individuals?
I recognized one of the state police members. I believe a second one was also a state police member that I'm not familiar with.
Okay.
And then 2 other members that I believe were Canton Police, but again, not familiar with them.
And these individuals were obviously, it's dark. You're not paying attention to them. You're not paying attention to what they're doing. They probably have hats and hoods and gloves on, I'm guessing.
Well, they didn't arrive on scene right away, so we were already well into our search before they even arrived on scene. The only one who was on scene originally was Lieutenant Tully.
If you weren't paying close attention to those 4 officers, those additional 4 officers, how do you know exactly what time they arrived on scene?
They weren't in the area we were searching, so they came on scene after we were already on our line searching, sir.
So they may have been in the area, but you didn't see them until your line search had already begun, and you made note of them, correct?
Correct. I don't know when the exact time they arrived on scene, sir, but they weren't on scene when we started our search.
Or they weren't in your vision when they started your search?
No, they weren't on scene, sir.
Okay. But you don't know, as you sit here, you can't say what time they showed up.
I do not know, sir.
And did they come at your direction?
They did not.
Did they come at the direction of any of your staff members, any of your colleagues?
No, we did not request them, sir.
Okay. So they were there for some reason other than why you were there?
That's correct, sir.
I may have just a moment, Your Honor.
Yes.
These individuals, you noted they were either from, I think you said 2 from Massachusetts State Police and 2 from Canton Police, correct?
Yeah, including Lieutenant Tully, probably three MSP and 2 Canton Police, sir.
Okay. Excluding Lieutenant Tully, who was working very closely with you, the other 4 individuals, they were in full uniform or they were plain clothes?
Plain clothes, sir.
And your focus, once you began your search, once you stood up the team, turned your cars around and realized exactly the grid where you were going to search, that's when what your focus was on, correct?
Yeah, I was focused on our search area, correct, sir.
And when you're searching a line, for instance, if it's a line that extends to your right or to your left, the search that you're conducting is literally right directly in front of you, correct?
Well, you're always looking left or right because you're staying online with your teammates, so you always have a full view of the scene you're searching, sir.
Understood. I'm not saying that you look down and never look up again, but I'm saying that your focus, the main focus of your search is directly in front of you. That's why you do a line search. So you can take small steps, search in front of you, move forward, search in front of you as a line, almost an entity, single entity moving forward, correct?
That is best practice, yes, sir.
That's how you make sure you don't miss an overturned leaf that you need to overturn, that there might be a knife under or a gun under or something like that, or a bullet casing, something like that, correct?
Correct, sir.
Or a tail line, right?
Correct, sir.
Come on, Jackson, make your point.
The world sort of collapses a little bit. Your focus is in front of you. You're obviously working with your team members left and right. You're moving forward very, very gently, very methodically, very technically as you move forward, and the whole line moves forward on that grid, correct?
Correct, sir.
So you're not necessarily paying attention to what's happening behind you, off in the distance, in the dark, to your left far, to your right far. That's not what your focus is on, at least at that moment, correct?
No, sir. Our focus is forward as we're moving forward into our search area.
Thank you. In addition to the
obviously.
5 individuals, Lieutenant Tully included, and the other 4, there was also another person that made contact with you from 34 Fairview, correct?
Yes, when we first arrived on scene, someone had exited the residence onto the front steps, front porch area, possibly of that mudroom.
I'm sorry, I didn't mean to interrupt.
Of that mudroom, so that right door, the exit, the door closest to the garage, sir.
Can you describe that person for us?
It was an adult male wearing a hooded sweatshirt.
Did that person approach you or one of your team members?
No, he never left the front door area.
Did he say anything to you or one of the team members?
He asked if we were here for what happened earlier. We replied yes, and he turned and went back inside the residence.
And as you sit here, you don't know who that person is.
I do not, sir, no.
But he's a male, I'm guessing middle-aged,
It was not a child, sir. It was definitely an adult male, sir.
adult male wearing a hooded sweatshirt.
Yes, sir.
Thank you. You testified that you recovered, having a hard time speaking, it's been a long day. I apologize. We'll try that again. You testified that you recovered a piece of plastic first before you recovered the shoe, or do I have that backwards?
No, there was one piece of taillight located before the shoe, sir.
Understood. You've also indicated that of the, I think you said 6 or 7 total pieces of plastic that were found, that all of those pieces of plastic and the shoe were found basically right next to each other, correct?
I don't know the exact distances, but they weren't too far apart, some several inches to others maybe a foot or two. I don't know the exact distances, sir.
Without assigning an exact measurement down to the millimeter, Lieutenant, you've earlier indicated that all of the pieces and the shoe relative to each other, just relative to each other, were found within a foot or so of each other, correct?
Eyeball, again, as the distance I just said, sir, from inches to maybe a couple of feet. I know they all are geomarked with exact coordinates that, could be measured out at a later time, which again would have been at the purview of the detectives, but we did not measure them. Again, all eyeball that night.
Understood. When I say, and it may have been a bad question on my part, Lieutenant, and if it was, I apologize. When I say a foot, within a foot of each other, I don't mean a foot apart. All of them, you've earlier testified, would be inside of a foot total, correct? Or maybe 2 feet now?
I don't think they'd be quite that close, sir. I think they were maybe in between each item, sir, or close to it.
I have just a moment, Your Honor. Okay.
Oh, God damn it.
A memorization contest about your prior testimony, but do you remember testifying about this specific issue? Here I go again. I can't speak. The specific issue about a year ago, back in 2022 at a grand jury.
Yes, I did, sir.
Okay. Do you remember exactly how you described where everything was with relative? May 5th, is that a fact at the grand jury?
Okay.
Relative to each other, do you remember how you testified exactly?
I believe I said within a few inches or a foot away. Yes, sir.
Excellent. You rattled off times and dates like I've never seen before. So it's exactly what you said. So within a few inches of each other, maybe a foot is what you said, correct?
That's what I said. Yes, sir.
Okay. So if it's maybe within a foot, this is 11 and a half by 8.5 piece of paper, maybe an area a little larger than this, correct?
Correct, sir.
Okay. As you found items of evidence, did you alert Lieutenant Tully to that specific piece of evidence?
Yeah, so I was not one of the members who found any of the evidence, but as my team members located something, we would halt the line. Lieutenant Tully was a short distance behind our line. We would get his attention. We would cease our operations until he informed us that he felt it was properly documented.
And ultimately, Lieutenant Tully was the person responsible for documenting that item. Is that right?
That is, sir. We fall under the incident command structure. He technically took the lead as the incident commander that night, sir.
And he did that through photography?
Yes, sir.
So you saw him taking pictures of the items in their place once they were found, correct?
Yeah, I believe he was the one taking photographs, sir.
And by definition, Lieutenant, as a search like this is being conducted, unfortunately, moving snow means possibly moving the items themselves, correct?
Potentially, yes, sir.
They might end up in a jump full of snow, you turn it upside down. That's not what a piece of evidence was to begin with, correct?
Correct. It's been moved at that point.
But in this case, nearly all of the pieces that you did find, including the shoe, were nearly next to each other, meaning within inches of one another, correct?
I don't know the exact distance again, sir, ballpark eye distance, but again, that is why we provided the GPS coordinates of each location, because we did stamp those with a handheld GPS as we found items of evidence, and all those locations were turned over with our report to be measured at the desire of the detective, sir.
Certainly, using that very impressive memory of yours, your memory back in May of 2022, May 5th of 2022, was that they were within inches of each other.
I believe that's what I stated, yes, sir.
Okay. Ultimately, you indicated that
Please be done, Jackson.
6 or 7 pieces were found, as well as the shoe. The search was suspended just after 6 o'clock, correct?
Approximately 6:15, sir. We stopped. We'd gone, like I stated earlier, we'd gone approximately 8 to 10 feet further south on the road without recovering any other pieces of taillight. We knew we'd already located the sneaker, so we decided to suspend the search at that time until possibly a future date.
And you were never called back out to the scene by Lieutenant Tully or anybody else, correct?
No, we were not, sir.
And did you become aware that over the next days and several weeks, there would be 40 more pieces of taillight claimed to be recovered at the scene? Did you become aware of that or no?
I was aware other pieces were located. I did not know that was the number, and I don't know exactly when I became aware of that. It was probably much later on, possibly at this location when I learned that information, sir.
And you don't know, as you sit here, you don't know whom it was that recovered those initial pieces, correct?
No, I've never seen the evidence log, sir.
And you don't know when those initial pieces were claimed to be.
I do not know.
When Lieutenant Tully and you had a conversation about shutting down the scene, was Lieutenant Tully's comment to you after those first few pieces were found that he was, quote, very satisfied that you had recovered everything that you were going to recover from that night, from that search? Okay.
Sustained.
Mr. Brennan asked you about the conversation that you had with Lieutenant Tully to shut the scene down, to clear the scene, correct?
Yes, so we conducted a debrief, and I gave him, again, as I mentioned earlier, we provide a probability of detection. I tell him what the chances are. I think we found our items we were looking for, and we determined to suspend the search.
Do you remember testifying last year that Lieutenant Tully indicated that he was very satisfied with what was found?
I don't know if he used the word very satisfied, but he was satisfied that evening that we had found everything we were going to find that night, sir.
Just a moment.
Okay.
And then miraculously, they just happened to find 40 other pieces over the course of a few weeks. Still such bullshit.
As you sit here,
I believe, yes, he was satisfied with the search. I just don't know if he used the word very satisfied or not, sir.
refresh your recollection, take a look at your transcript.
I'm sure it will, sir.
It's the one thing you didn't remember. Man. Highlighted portion, Lieutenant.
Thank you, sir. I'm just going on the date. Is this from last year, or would this be from the grand jury, sir?
June of last year.
Okay. Yes, sir. So it does state here that I stated he was very satisfied with the search.
Refresh your recollection, that was the word that he used, or at least you remember him using at that time.
Yeah, I believe, to the best of my recollection, sir.
Yes.
Thank you, sir.
May I have just a moment, Your Honor?
Yes.
Okay, Jackson, that's longer than a moment. You're starting to piss me off now. It's Friday. I'm tired and I want to go home to bed.
Lieutenant, there was one other thing that I wanted to ask you about, which is you had indicated to Lieutenant Tully at some point close to 6 p.m. or so, it would be helpful if you and your team had a photograph of what it was you were looking for, correct?
Yeah, I believe after we found the first piece or two, I asked him if he had a photograph that we could look at just to see how large of an area, how large of a piece we were looking for, sir. Yes.
Fine. So that would just timing-wise, if you found the first piece at 5:45, first piece or two, maybe 2 or 3 or 4 minutes later after that, maybe 5 minutes later. So let's place it at 5:50, close to 6, something like that.
Yeah, probably between 5:45 and 5:50, possibly, sir.
And you said to him at the time it'd be helpful if we had a photograph of what it is we're looking for, correct?
Yeah, I said that would help, yes, sir.
And Lieutenant Tully told you that the vehicle did not have a photograph because it's still en route from Dayton to being transported to Canada, right?
He did say he did not have a photograph and it was being towed back.
Okay. Thank you, Lieutenant.
Thank you, sir.
Okay, Mr. Brennan.
Thank you.
I get snappy spanky. I want to hurry up and get to the fireworks.
Sir, you mentioned that there were about 5 people not on your CERT team at some point arriving at Fairview Road or the area of it.
Yes, that's correct, sir.
3 of them were Mass State Police. You mentioned Tully and 2 of his colleagues.
Correct, sir.
Did you see anybody taking photographs of the items that you found?
Yes, Lieutenant Tully was taking photographs while we were there, sir.
And did you see somebody putting the items in bags?
Yes, they did, sir.
Was that one of the 2 people that were with Lieutenant Tully?
Yes, correct, sir.
And you mentioned there were 2 Canton police officers. Were they part of the search?
They were not, sir, no.
Were they on the grid?
They were not, sir.
Did you ever see them in the area on the grid?
I did not, no, sir.
They were there. Were they involved in any way in the crowd?
Mostly does it because I'm bored.
They weren't the only people that ever came on scene other than us, and those local officers were at some point the media did arrive on scene.
When you say on scene, is on scene different than on the grid?
Correct, just in the general vicinity, sir.
Did you know what the Canton police officers were doing?
I do not know, sir.
Did you ever see either of them ever come on your grid?
They did not know, sir.
Did you ever see anybody place or toss or throw anything onto your grid?
I'll allow it.
Did you ever see anybody place or toss or throw anything onto your grid?
I did not know, sir.
Did you ever see anybody intrude on the grid and leave an item?
Choose a different word.
Did you ever see anybody physically intrude upon your grid?
No, no one did that, sir.
You were asked about best practices memorializing. The person who was taking photographs.
Hold on for a second.
Slow down a little, Mr. Brennan.
You mentioned best practices of memorializing items. And you also mentioned Lieutenant Tully was taking photographs.
Yes, that's correct, sir.
Do you know if those photographs were time and date stamped?
I believe they were, sir.
Is time and date stamping with photographs best practices in memorializing things?
Yes, they are, sir.
Now, before you defined the grid and before you began that search, you knew other state police officers, didn't you?
Yes, I do.
Did you know a person by the name of Trooper Yuri Buchanan?
Yes, I do know him, sir.
Did you know somebody at the time known as Trooper Michael Proctor?
Yes, I do know him, sir.
Were either Michael Proctor or Trooper Yuri Buchanan at Fairview that night?
No, they were not, sir.
Did you see them at any time from the point you got there at 4:56 p.m. until when you left?
No, I did not see them there, sir.
You mentioned that somebody came out of a side door at 34 Fairview who had a hoodie on.
Yes, that's correct, sir.
How long were they outside for?
Maybe 10 seconds, sir.
Did they at any time interfere with your search?
No, they did not.
Did they at any time try to discourage or dissuade you from searching?
Objection, Your Honor.
Next question, I'll sustain that.
Did that person do anything to impede your search?
No, he did not.
You were asked about your conversation with Trooper Tully,
Yes, sir.
and he mentioned, or you characterized, he was very satisfied that what you had found, everything you were going to locate at that time.
That's correct, sir.
Did he ever suggest that he expected that you would not find anything else?
No, he did not.
Did he ever suggest that there was no other trace evidence there?
No, he did not.
Was there a discussion that he or you or other people may come back to search further at a different time?
We offered to come back at a later date, and he just accepted our offer, but we were never contacted to come back, sir.
When you offered to come back, was that based on your assessment that it was a difficult area to search?
Correct. Again, as we talked about probability of detection, we'll base that on 10 different categories, give him a baseline percentage chance of it. Would we have found what we were looking for? I told him there was a good chance we did not locate all the evidence, asked him if he wanted us to come back at a later date, sir.
And when you mentioned that you couldn't finish the search because of the grass, tell us a little bit about what made it difficult because of the grass.
Even using the push brooms, we couldn't properly move the snow off the grass as we were moving it. And with the dark, even the headlamps, I didn't feel like we were clearing it enough to continue searching it. I think our best efforts would be to focus on the street because I was more concerned about eventually the plow coming in, clearing curb to curb and moving any evidence that was on the street. My thought was if with the grass not being able to properly clear it, at least that would be contained to be searched at a later date as the snow melted.
And given those assessments, is that some of those reasons why you offered to come back?
Yes, sir.
I've shown you some photographs you've identified about some of the pieces that you found or the pieces that you found that night. I'd like to show those photographs to the jury.
Okay.
If we could show Exhibit 73, please. Is that one of the photographs you identified
You know what
earlier?
they needed?
Yes, it is, sir.
Is there a chance to show me that we can do a close-up of that? Can you describe what you're seeing?
It's a piece of clear taillight. It's got rigid edges, some indentations on it, distinctive markings.
Objection. How do you not
Did all
object to
the
that?
pieces you found have those type of markings on it?
Not sure if they had those exact same markings, so I'd have to compare the photos.
Was there different colors of pieces that you found that night?
Yes, we also found pieces of red taillight as well.
Could we see 73A, please? Without blowing it up, if you could go back. Is 73A a picture from further away of the same piece?
Yes, that's what it appears to be, sir.
Was it easier to see these pieces that night in person than it is in photos, or was there any difference in the ability to identify these pieces?
Objection, Your Honor.
Sustained.
When you saw the piece from where you were standing, did it look any different than it does in this photo?
No, it doesn't, sir.
Can we see 75, please? In that picture from this perspective, can you see any pieces of taillight?
There's a piece of
think we can
red
see.
tail light in the left-hand side of that photo, sir.
That's horrible.
On a little bit of a mound?
Correct, sir.
Is that where that piece was found, on the mound?
No, that's the photo, like we discussed earlier, sir, that came up with one of the shovels. And you can see, when you get close to that photo, you'll see the actual molding of the overturned shovel.
So it was scooped up and then placed on that mound?
Correct. As the trooper overturned it to start beginning to sift through the different layers of snow, that's where he deposited that snow, sir.
Could we get a close-up of the left side of that picture, please? Can you see the shovel marks near that piece?
Yes, they're directly behind it, and off to the left, you can see the molding of the shovel.
You can see a bit of a divot to the left of the red.
Yes, correct, sir.
Is that part of the imprint from the shovel?
Yes, it is, sir.
Could we see 75A, please? Is that a close picture of the same item?
Yes.
The imprint, does that give you a clearer view of the shovel you were speaking about?
Yes, it does, sir.
Could we see 76, please? Is that one of the photographs you identified earlier?
Yes, it is, sir.
And that piece, was it found at ground level,
Yes, that photo is where that item was located, sir.
touching the ground?
Yes, sir.
Could we get a close-up of that, please? And if we could have 76A, please. Is that a picture of the same item?
Yes, it is. Just zoomed in, sir.
You can close that, please, and turn the lights on. Thank you. To be clear on the timeline, your colleague arrived, first colleague arrived at what time?
4:54 p.m., sir.
And you arrived at?
4:56.
You mentioned that it looked like fresh snow.
Yes, sir. The area we searched was fresh, undisturbed snow.
And when you got there at 4:56, when you described fresh, undisturbed snow, was that your impression when you first got there at 4:56?
Yes, I realized that the plow had not cleared curb to curb.
You began your actual search at what time?
Right around 5:20, we wound up again. We moved a couple of our cruisers around just so to add extra headlights, extra lighting on the scene itself.
And the first piece of evidence was found at what time?
5:45, sir.
Your area that you searched, did you say it was 8 to 10 feet?
No, sir. The area marked off was just over approximately 60 feet. We'd gone about 8 to 10 feet towards the end of the search without locating any more items, and that's where we suspended the search.
How much of your focus was near the street area?
Only 99% of it, sir. As soon as we got to the grass and realized we couldn't clear it properly, my main focus was on that street, just again because I was concerned about the plow coming through at a later time.
You were worried that if you didn't finish the street, there could be some impact from plowing?
Yes, sir.
And did you say 99% was the street area?
Yeah, approximately, sir.
Thank you very much.
Anything, Mr. Jackson?
Yes, briefly. So the search went approximately 60 feet.
That's the area I marked off, sir.
And in that 60 feet, you started close to or adjacent to the front door, correct?
Correct, sir.
And in that 60 feet, you were doing the type of search that we described earlier, that you described earlier, about going just a few paces at a time and starting to move material out of the way to try to get down to the surface, correct?
Yes, sir. All working together. Yes, sir.
And you did not find 40 pieces of taillight at or near or on that street or the lawn or anyplace else, correct?
Yeah, I don't know the overall number, sir, but
And neither did your colleagues.
correct, sir. We've never been notified how much has been located.
The only thing that you found was
That's not what he
concentrated
fucking asked.
maybe a foot or 2 feet in diameter. You said 6 or 7 pieces and a shoe, correct?
That's what we located. Yes, sir.
You didn't find a black baseball cap, correct?
We did not know, sir.
And in the photographs that we've seen, that's clearly not undisturbed snow, correct?
The photographs are us moving after having moved the snow, sir.
Some of it is y'all moving the snow. Some of it is disturbed snow on the street or at the curb, correct?
After we had moved it, yes, sir.
You indicated that
So where the fuck
Trooper
did the other
Proctor and
40
Trooper
pieces come
Buchnick,
from?
you know both of them, correct?
I know who they are, yes, sir.
Or know who they are. When Trooper Tully told you that the vehicle was en route and could not provide you a photograph at, let's call it 5:50 p.m., did he tell you that the vehicle had actually been secured at Canton PD about 1.5 miles away at 5:35 p.m.?
No, he did not say that, sir.
Did you know through any other means that that vehicle was just 1.5 miles away at 5:35 p.m. before you ever found the first piece of tail light? Did you know that?
I did not know what time it arrived, sir.
Thank you.
Do you know what time Trooper Tully told you he did not have a photograph?
It was sometime after we found the first piece, sir, so sometime after 5:45, sir.
Thank you.
All right.
That's all I had.
All right, Lieutenant, you are all set, sir.
Here we approach.
Okay. One up, please.
Thank fuck for that. Do they come back at all, or is it?
All right, so jurors, every day I've been asking
they came back.
whether we are on track. Usually, I haven't reported it to you as much, but I can tell you now that we are definitely on track. Maybe a little ahead of schedule, which may just mean down the road a little bit, we'll be back on track. But because we're on track a little ahead of schedule right now, we're done for today. So we'll let you leave for today with those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be very careful with your social media use. We'll see time.
All rise for the court, please. Close your books and follow me.
Goodbye.
I want them to go through that.
Alrighty, starting day 11. Don't know why, but the internet's getting a little bit choppy all of a sudden. Starting off with a sidebar, as we do pretty much every day. God, I'm glad that we're at least done with that guy, because holy crap, that was just... Okay, we get it. You're the one that did the search. You found 6 pieces. You covered a 60 square foot area and found 6 pieces and a shoe that does not appear to be the shoe that is on the goddamn stand now anyway. And I'm sorry, you can tell me that that was in shadow or whatever else when they took the photo. That's a load of shit, as far as I'm concerned. More or less inverted the colors of the shoe. I got a splitting headache. I can't tell if it's from lack of caffeine or just because I worked hard today. And by hard, I mean harder than usual, obviously. I always work hard. We work hard, we play hard. Okay, I'm what, a day and a half behind? You'd think that Court TV could trim some of this shit out.
All right, good morning again, counsel. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keith.
Jury, in case I'm hearing should be truth, whole truth, and nothing but the truth, so help you God. Yes.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes, in various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes,
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes,
Specifically, regarding the digital forensic evidence, did you meet anybody to
This is
obtain
where,
a phone?
hang on. So this is where they're going to start jumping around, trying to desperately not mention Trooper Proctor. Interesting. And when did Keith lose his O? Presumably this guy isn't quite as Irish.
yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes,
Is that different than analyzing the phone?
yes,
Were you involved in analyzing Kerry Roberts' phone?
no,
Were you involved in analyzing Jennifer McCabe's phone?
no.
Was your role limited to attaching it to Gray Key and doing the extraction?
That is correct.
And did you do that?
Yes,
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes,
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search, very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
He was
And
the
why would you
baggy
do that?
bitch front
to,
of him. He was
to
the baggy
secure it.
bitch.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a evidence bag.
Do you know if those photographs were timestamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
I'm sorry, a what? A Nicky shoe. I've heard it pronounced Nike. I've heard it pronounced Nike. I've never once heard it pronounced Nicky. I'm sorry, that broke me for a second.
74A, please. 74B? Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then
I've done a
retaped?
showy, but
Yes.
not from a Nicky.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission,
How do
can
they
we show
not
the item?
learn just to get an exact on it?
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
Oh, fucking
Right, any objections,
shit.
Stephen?
There's no objection.
Six 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times. Then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please.
The time written on the bag really is irrelevant then.
And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you can take that down, please. Thank you.
Well, it's
570.
not only that, Kathy. As far as I'm aware, weren't the
Yes, sir.
colors on the damn sneaker
Court permission, I'd
reversed?
ask
Wasn't it a black
the
bottom
trooper to
with
open the
white
bag and
top?
show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I do not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces or is there another piece in that bag?
There's another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put two.
Do you know if the other piece in the bag is piece that broke off? Do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well?
I know it'll be petty, but I'd be objecting all over the place here right now. Objection. How does he know it's a tail light? Does he have personal knowledge that it actually is a tail light?
Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay. Thank you, very much.
Okay.
Sidebar. God damn, the caffeine can't do its job fast enough.
You to remove that chip. I'd like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
678.
So we're going to mark the little chip.
You
Ms.
would like to mark
Giannetti
it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
678.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please? Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a
I
photo.
mean, look, sometimes individual pieces of evidence can be bagged
Yes.
in the same bags.
The
I
piece
would
of
have
clear
still
plastic.
expected them
Is
to be
that the
moved
second piece in the bag,
another
separate from the last exhibit?
Yes.
evidence bag.
Is there an
at
accurate
some
depiction of how you saw it that morning?
Yes, sir.
I move this into evidence as an exhibit, please.
There's no objection, Ms. Giannetti?
There's no objection, Your Honor.
679.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to vote? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items in evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct.
It's the form that you get to sign before you spread your legs. But seriously, these days people are actually doing that. And I don't blame
an
them.
extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated the time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the.
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet.
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Okay.
And here comes the attempted distance from Proctor. You keep his name out of your mouth. Hang on. Sniffing contest. Ow.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
No, no.
I might have a cigar when I get home. I feel like I've earned one. Although it'll be dark as fuck. Might have to wait till tomorrow.
I've placed a
Can't wait till I have my
document in front of you. I
own
just ask you to
house.
read that silently to yourself. Look up at me when you're done. And sorry, Trooper Keith, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you
I'd just
don't
like
have to
to-
brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
While they're refreshing that, what's everyone going to do this weekend, chat? It's Australian Mother's Day on Sunday. So, got some plans there. I'm not going to say them out loud in case Lady Overlaw'd watching. But,
Having
go out and
reviewed
pick up
that
some
report, does that
packages.
refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
And the two of you would have participated in that interview together, correct?
yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report,
Ooh,
correct?
PAX would be fun.
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. May I approach, Judge?
Yes.
You are. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking this, you retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes,
But lead detective or lead investigator
look at
Michael
her, baby.
Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
Oh, I'm sorry. Again, if you read that silently to yourself and look up at me when you're done.
I've got That's the burp. "13-year-old Chihuahua. Wow. Okay. If it's got big ears, make sure you name it Raider."
Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes,
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
this is CF McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes,
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes,
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
May we approach? No, stand there and do your questioning. Fully expect that from Bev, to be honest.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes,
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
he could have.
Cheeky way to get that
He's
in.
been
I
on the
like
job
it.
longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes,
That was done at the medical examiner's office
the medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes,
Had you met her prior to that day?
no,
Had you spoken to her prior to that day?
no,
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Stage, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
there was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes,
You also learned that there was a small cut above his right eye, correct?
yes,
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
What's the matter, Trooper? Don't want to use the word abrasion?
May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one.
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct? You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct? You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Objective line of motion.
Sustained.
May we approach?
For fuck's sake!
Jerry, feel free to stand up.
He can testify to his own observations of what the medical examiner observed. If he's standing over her shoulder, watching her twist his arm, looking at the fucking dog bite marks, I'm pretty sure he can testify to that. Do I have any Panadol? I don't think I have any Panadol. Hello, wife. It's a good question. I have no idea. Do we still have anything in the fridge? It's probably too late to grab the chicken stuff out of the freezer because it's not going to cook. Well, I mean, A, it's not going to defrost, let alone cook. Special blindfolds that have thick material covering the evidence that a cop might be guilty. Honestly, it's pathetic.
We watched.
And babe, to be honest, I got a splitting headache. I'm not sure if it's caffeine withdrawals. I'm trying to scull a Coke as quickly as I can, but I'm pretty easy. So as long as it's probably not Chibi Nuggies, although we know what the munchkin's going to want.
Dr. Scorti-Bello as she was conducting the autopsy.
Yes.
Did she appear to be looking at John O'Keefe's body?
It's the same thing. Just
I mean, if you want a
direction
divorce,
were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking?
Your daddy's tired of this shit too. Oh my god.
Looking at the ceiling, Trooper.
She was doing her job conducting the autopsy.
And in order to do that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank
Not
you.
in.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scotty Bello during the autopsy?
Yes.
If you
And
provide
gave her
information, you're giving her
you don't want to call it
input.
input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct? I have nothing further.
No, not thank you.
All right, you're all set, Trooper.
Thank you.
So, jurors, this break we're going to take now? All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess after. I want counsel to stay.
All right.
Love you, babe.
Close the door, follow me.
My argument.
Oh, God. So are they, I can't see, are they actually doing it at sidebar? Are they going to do motions in open court?
I can't stress enough that this more about what we talked about. So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what.
What the fuck do you mean that it should have been brought up already? If the decision was in March, there's a good chance that the written judgment wasn't available prior to the start of this trial, you month. Jesus.
But I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, a court is a judicial proceedings of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
She doesn't like that he's backing her into a corner. You
Okay,
can
thank
hear
you.
her getting tense already.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it from
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history,
Right.
but what the court also got.
She's actually trying to limit what he's allowed to impeach on a so basically this bitch Hyde has testified in another case so far, and her evidence based on whatever, because I haven't seen this Maryland case, but it was deemed unreliable and not usable by the court. You know what? Fuck you too, asshole. You could have went around. You chose not to. Dipshit. And she's sitting there trying to tell him, oh, well, if you want to impeach the fact that she gave unreliable evidence in another case, you have to limit it to a specific area. What the fuck? No.
That was Apple source codes. That she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I won't explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a...
Bull fucking shit, it's not relevant. She's trying to use the same methodology that was determined not to be admissible and usable in another jurisdiction. And there's court rules in Massachusetts that say that said decisions can be used. So fuck you, Brennan. It is completely relevant and it is completely appropriate. He should have every opportunity to cross-examine her on that
specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none.
I really
This
can't
is not a
follow
denouncement.
him. So
This
you
has been
admit
found
enough
incredible.
of a
There's
dipshit.
nothing
You don't
about her
understand the
methodology that
argument.
has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whitman.
Oh, it was. The 227 timestamp would.
No, that was raised, but this, what
Well, no,
was
'cause it's based on her evidence that she
problematic
gave
in
in Maryland.
Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been advertised with regard to Apple source codes. And if I could, Your Honor,
Okay,
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
no one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data stats. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, 1, doesn't exist anymore, or 2, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? But one of the fundamental ways you do it is, and I don't mean to dehumanize her. I won't even use the term Daubertized anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. but I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint, she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion
That's not
that
the question she just
timestamp
asked you,
227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. This is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion. It wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. You just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case. And even if it wasn't, it shall be in evidence. So there's two issues here. And I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says, ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're separating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology. With regard to her PowerPoint, you heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right. And Mr. Leslie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after
then the cross-examination is necessary and you have to suck it up, Buttercup.
Could be addressed at that point. There was no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
But I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask one quick? May I, Mr. Gray?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Well, that was a bit of a shouty match. But again, as we've come to expect from Alessi, he's 100% on point. Based on the wording of the Massachusetts Rule 39, the superior case comes in as evidence irrespective because it relates to the witness that the prosecution is trying to call. So the fact that Brennan's just trying to limit what they're allowed to do on cross-examination is just a dirty tactic. Honestly, he's the one who has to he's the one that has to meet his burden. Who thinks Bev will do the right thing here? As if. I don't think Bev would even know what the right thing to do there is. And, I wish I had more time on this. You're a fucking judge. And it's pretty fucking straightforward as to how this is being laid out. So, anyway, while we're in the middle of that, just out of curiosity, I'm curious, how many people are actually watching this with me because they want to watch it with me or they enjoy my commentary? And how many of you have just got nothing else to watch? Just put ones in chat if you're actually here for it, or two if you just have nothing better to do. Because I appreciate everyone watching, but I'm well aware that, most of you are probably watching a first time around with everybody else.
Goodbye.
What do you mean, goodbye? Court is on short break. Okay. I don't know that we're going to get through much more. I'm actually half tempted just to pause the video there. Because, I'm, 5 minutes from home anyway. I'm just going to let that run for the minute. If they come back, they come back. It's a long break? Okay. Yeah. Because I'll have to do another stream. I mean, now that tomorrow is sort of opened up for me, I'll be able to fit some more time in. I'll try and get something done in the next couple of hours. I can't promise that, but I will do my absolute utmost. Oh, thank you, Jim. I can see why people said that there were fireworks, because that was very emotive. Unless he knows his shit, you know when he gets up and he's making emotion like that he is going to have dotted every I and crossed every T. And just the way that he why was he yelling? He was getting very emotional, and I don't think that's a bad thing. He was hammering both the facts and the law then. He didn't have to hammer the table. He just got to anyway. And I think Brennan assumed that by appealing to emotion that he'd be able to get Bev to tell Alessi to knock it off and just deny the motion. Did he call the judge a bitch? Not as far as I'm aware. I'll do it. Judge Bev, you're a bitch. That's really straightforward and easy. I'll leave it on a cliffhanger. Well, might as well. I mean, look, straight fact of the matter is the witness comes in. She was never not coming in. It's whether or not he is allowed to use that during cross-examination, and I fully expect that he should be allowed to. Because if she doesn't, if Bev tries to restrain what he's allowed to ask her about, I feel like that's an appealable issue. I mean, if this woman has literally been found to be in a... What is going on? Where is my auto braking turned off? It is too. If this woman's been found to be an unreliable witness in other jurisdictions, that should absolutely be brought to the attention of the jury. Because much like the judge, the jury is under the assumption that everyone put before them that's an expert is at least credible and reliable in what they're going to say. The whole point of being able to impeach the witness is to say, hey, by the way, you fucked up previously on something incredibly similar. So, like I'm in witness protection. No, it just gets fucking dark very early here now. It's only just gone 6:25 in the evening. So, you know, roughly the same time that officer was finishing up his search of the front yard at the Albert's house. It's funny how the seasons change and lights and all that sort of shit, isn't it? Babe, are you still watching? I have a question. So, but while we've got a bit of a break, one thing I do want to say is I was looking at the fact, like, I'm well aware that the prosecution's just about done with their case in chief, and from the sounds of it, they're not going to be calling Proctor. And someone asked me whether or not there would be any point to them still, whether or not there'd be any point to the defense calling him. Given that they wouldn't be able to ask leading questions, and he'd basically be able to get up there and pretty much, well, answer vaguely and offer the prosecution an opportunity to twist various things in pretzels to muddy the water and whatever else. And I actually looked into the Massachusetts rules as to whether or not Proctor would be classed, whether or not they'd be able to class him as a hostile witness. Now, automatically, a defendant is allowed to bring a witness as an adverse party and treat them as a hostile. Jesus. Yeah, it's a 60 zone, mate. Well, see, that's it, Coke Fury. I'm thinking that the defense is going to call him, but I do think that they're going, like, I'm actually partially wondering whether or not the fact that he was fired is played into part of the strategy. Because even if they do call him, because he was fired, he can no longer be classed as an adverse party. He's no longer a hostile witness. So they don't automatically get to treat him as someone that they can ask leading questions of, someone that they can impeach, and someone that they can beat around a little bit. I mean, they could call him, and he could quite. Well, see, that's just it, right there. They've got to be very careful about what questions they can and can't ask, because they'd be calling him as part of the defense's case in chief. Because he's not an adverse party or a hostile witness, they can only ask open-ended, non-leading questions. And that will hamstring them more than you would think. Because what can they ask? Were you employed as a Massachusetts state police officer? They can't even really ask that, because that's a yes or no question. Where are you currently employed? What was your previous employment? What? What were the circumstances around the termination of your employment? I suppose I could get it that way. Like, they'd have to structure the questions very carefully and very succinctly. And then it's open slather for Brennan. I mean, unless there's case law. So the adverse witness rule, particularly in relation to criminal cases, automatically applies to any officer of a state authority, or anyone that specifically has inverse interests to the defendant or the other party, because it applies differently in terms of whether or not you are in whether or not you're in a civil case or a criminal case, obviously. But basically, if he'd still been employed, he automatically would have been treated as an adverse party, because he would be a member of the police force. And if they can make the argument that his interests are adverse to Karen Reid's, then they can still do so. I don't think that they'd be able to make that argument. And pretty much he can pretty much just sit there and decline to answer pursuant to his Fifth Amendment rights. Because anything he says could potentially incriminate himself for how badly he fucked up the investigation. I'm not saying that he should be sitting there saying that. I'm saying that he could try it. Oh, Jesus. But it would be very interesting. Also, I'm not sure what I'm going to do with these streams after the trial ends. Starting to think that I'm going to start trying to get up early before work and go back to doing the the old Law Patrol style things. Stream between 6 and 7, out the door by 8. Listen to an audio book in the car on the way. I don't know. We'll see how it pans out. But look, like I said, do I think they'll call him? Yeah, I think they kind of have to. But I think they'll have to play it really well. They're going to have the questions ready. They're going to have to know how to handle Brennan's cross-examination of him, because Brennan's going to have a much freer reign, shall we say. So. But all right, peeps. I'm going to head home. I'm assuming the wife pissed off, so we'll pick this up later on and hopefully get a bit closer to being live. But as always, people, please remember, you are not a piece of shit. You have value in your contribute to society, especially for being here. Thank you to everyone that's hit the like button. Thank you to everyone that has joined up as new subs, if you have. But as always, stay healthy, wealthy, and wise, people, and I'll catch you all shortly. Cheers, peeps.
And again, on your way out, please do me the favor of hit the like and subscribe button if you're so inclined. It costs nothing. It's absolutely free, and we'll be friends forever. Bye now.
Unfortunately, some members of the media use their platforms
to push their own personal bias.
and agenda to control exactly what people think. This is extremely dangerous to our democracy.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.